Oregon is an equitable distribution state that presumes a 50-50 equal division of marital property as the starting point for divorce proceedings. Oregon courts can deviate from equal division based on specified factors, but must begin from the equal division presumption. Oregon defines marital property broadly. All property that spouses acquire during the marriage, regardless of how it's titled, is presumed to be marital property subject to the equal division presumption. Separate property, premarital assets, gifts, and inheritances can be set aside, but the burden is on the claiming spouse to establish the separate character of the property. Oregon applies a just and proper equitable standard in fashioning deviations from equal division, considering factors such as the contribution of each spouse, the duration of the marriage, and economic circumstances. For creditors, Oregon's strong equal division presumption means that a divorcing Oregon debtor's spouse likely receives approximately half the marital estate, and the debtor's enforcement target assets are the remaining half. Oregon's homestead exemption is $40,000 per person, $50,000 if the debtor is age 65 or older. This moderate exemption leaves substantial real estate equity accessible to creditors above the threshold. Wage garnishment in Oregon. Oregon follows the federal garnishment limits, 25% of disposable earnings. Oregon provides that certain sources of income, Social Security, unemployment, disability, are exempt from garnishment. Oregon does not recognize tenancy by the entirety. Jointly held property does not receive special creditor protection based on the marital status of the co-owners. Without tenancy by the entirety protection and with a moderate homestead exemption, Oregon's enforcement environment is relatively accessible for real estate and personal property execution. People Locator skip tracing provides Oregon debtor investigation and supports enforcement proceedings. Visit peoplelocatorskiptracing.com to place your order.